Okay, well, we are back for the second part of the economic substantive due process lecture. So up until this point, we've seen that the court has applied the principles of government neutrality and police powers jurisprudence to efforts by states to regulate private economic concerns. And in a case called Munn versus Illinois, the Supreme Court upheld the use of non-neutral legislation to interfere in a private contract because the state of Illinois had defined a specific, identifiable, legitimate public purpose. That purpose was to prevent grain elevator operators and grain storage companies from defrauding the public. They were colluding and setting prices for farmers. They were doing very much like the meatpacking industry was doing in some of the cases we read under the Commerce Clause. And so the court was very supportive of Illinois, and it ratified and justified and understood that Illinois could interfere in private contracts where those private contracts involved fraud, defrauding people. The state could act to stop fraud. Well, now we get to the granddaddy of all substantive economic due process cases, Lochner versus New York. Now, Lochner versus New York had to do with a state regulation in the state of New York that regulated the number of hours a bakery employee could work. And there's been a lot of discussion about this case, and the court maybe didn't think that regulating the baking industry was all that important. I mean, it was bakers, right? How hard can it be to be a baker? More importantly, how dangerous can it be to be a baker? You have to understand, historically, the baking industry in the United States involved more work-related injuries and deaths than any other industry except for the steel industry. There were these huge buildings with massive furnaces and ovens that baked bread for wide distribution all across states and regions, and people would die of heat exhaustion. Their health would be impaired. They would breathe in the flour, and they would their lungs wouldn't function properly. They would get asthma and sometimes even lung cancer. It was a very, very difficult industry that the state of New York wanted to step in and regulate, and it did so in a number of ways. So first, they passed the bill called the Bake Shop Act. I'll just read it from the text here. It says it's a law that prohibited employees of bakeries from working more than 10 hours per day and 60 hours per week. The state justified the law on two grounds. First, New York had the authority under its police powers to regulate working conditions while taking into account local circumstances and community standards. And second, the state, through the police power, had the authority to regulate for the health of both consumers and workers. So we see that the state of New York is attempting to justify this interference in labor using public health, safety, welfare, and morals arguments, at least the first three, public health, safety, and welfare, using their police powers to protect workers and consumers. Now, this is non-neutral legislation, okay? This is not, the Bake Shop Act was not an act of general applicability. It targeted bakeries, and it set limits on the number of hours those employees can work. In Munn, the court upheld the setting of prices. The state of Illinois was not attempting to regulate labor conditions or private contracts that laborers and business owners would enter into. But here, the state of New York is doing that. And by a 5-4 vote, the majority said that New York may not use its police powers to interfere in contracts. Why? The court actually argues, if you read this closely, it argues that it's protecting the bakers. It's protecting the right of employees to contract for as many hours as they can get out of an employer to make as much money as they can. The court says the act here is not a health law, but is an illegal interference with the rights of individuals, both employers and employees, to make contracts regarding labor upon such terms as they may think best or which they may agree upon with other parties to such contracts. An interesting assumption that the court makes here is that employers and employees have equal power within the marketplace. The truth is, though, that an employee could not go to one of these employers and say, I only want to work 10 hours. That's all I want to work, and I'll work for this wage. The employer would laugh them out of the building and then hire one of the 200 people, jobless people who are standing behind them waiting for a job, and probably offer them less money and tell them they had to work more hours. So one of the assumptions the court makes is that employees have equal power with the employers. But that's not true, actually. Employees could not unite to bargain collectively. Employers had a tremendous amount of leverage over them because jobs were scarce, and as a result of the Industrial Revolution, more and more people were moving to cities, and so there was a flood of labor on the market. And furthermore, the court viewed the regulation of working hours very differently than it viewed things like stopping fraud in the setting of rates. And so it strikes down the act here. Also, you might note that the court did not have much evidence in front of it in the record of problems with the baking industry. Now, one of the important things to note here before we get to Mueller, one of the important things to note is that Justice Holmes dissents, and it is a scathing dissent to which the members of the court do not reply. He says in one of the most famous lines in the history of the Supreme Court, the Constitution does not endorse Herbert Spencer's social statics. What he's saying there is that the Supreme Court is substituting a view, a theory of industry and business that exists outside the Constitution for the police power of the state, which is the more ancient power. He says that they are intervening on behalf of employers and endorsing a particular social economic structure that advantages some people and disadvantages others. And they're dressing it up in this language where they're saying they're supporting employees. The court doesn't respond to that, and you often see courts responding to statements like that in dissents because they're trading their their opinions back and forth all the time. And so when a majority is accused of something like that, you often see them respond in their opinion. They don't respond. Why not? I think it's because the court really believed that employers and employees occupied a very similar position of power in the marketplace. And the reason they believed that was for the first 100+ years of the nation's history, that was the case. Furthermore, if you found yourself in a position of economic dependency on someone, well, go start your own business. It was relatively easy to do so in the United States at the time, or go somewhere else. If you can't find property, go buy property somewhere else. If you don't like the terms of the contract you're in, go somewhere else. The West was opening up, and there was lots of opportunities out there for people. What's anyone complaining about here in New York? I think they really believed it. I don't think that they were endorsing a particular socioeconomic theory, and that's why they don't respond to Holmes. Okay, so I also want to stop there with Lochner and go on in another lecture to Mueller and also to West Coast Hotel.